All right, welcome back. We are reviewing our basic understanding of company law and we're going over the 5 principles of company law that we've been talking about. So far, we've talked about legal personality and limited liability. In this segment, we'll figure out why shared and transferable ownership of shares is important. If you take a look at the Indian judicial system, there is one fact that rises head and shoulders above pretty much everything else: delays. We know that the Indian judicial system is fraught with delays, that there aren't enough lawyers, there aren't enough judges, more importantly, to handle the sheer amount of caseload, which means that many cases languish in courts for years, perhaps decades. Now, you'll notice that most of these cases are about shared ownership of property. Whether it is, well, most likely it is about partition suits, right? Where family members cannot come to an understanding or some kind of a resolution as to who should own property which has been passed down from their ancestors, or co-parcenary property. Property disputes or shared ownership of property constitute a huge percentage of all the caseload that is in the Indian judicial system right now. The reason being that it is very, very difficult to come to an amicable understanding of how assets can be shared. People will act in their self-interest. People will be self-opportunistic. And as a result, they will want more for themselves, creating conflict, creating disputes. Now, some of the most valuable assets in the world are companies. You think of companies like Tesla or Apple or Google or Alphabet or Amazon. These are all assets that can be bought and sold. And they're also some of the most valuable assets in the world. So how do we have shared ownership over these assets? Well, we simply have an imaginary umbrella called the company. We break that company into smaller units called shares, and we say that each shareholder owns and has control over X number of shares. What this means is that the company owns the assets that it owns as a separate legal entity. Remember, we discussed in the previous segment that a company should be able to own property in its own name. So all the assets in the property are owned by the company itself, but I own a slice of that pie. That slice of that pie is what my shareholding is. And therefore, that gives rise to shared ownership in a company. However, this does not mean that as a shareholder, I have any rights over the assets of the company itself. Remember, the assets of the company are owned by the company, not by the shareholders. The only right the shareholder has is whatever rights on its own shares. And if you recall, shares can be transferred, can be treated like goods under the Sale of Goods Act. Now, this becomes really important for the continuity of the company. Now, because a company has been designed, or our understanding of the company has been designed to ensure that many people can pool their financial resources together, we should be able to allow them to transfer their ownership in this company to other people. And therefore, even if I transfer my shares to another person, the company continues on. Shareholders may come and go, a company is forever. Which means that we must allow transferable ownership of the company to any third party. However, as we've discussed earlier, the shared transferability of companies can be restricted in the case of private companies. However, they cannot be restricted in the case of public companies. So this was on shared and transferable ownership of a company. Now let's come to the fifth and final sort of principle on which company law is built: the separation of ownership and management. There is no separation of ownership and management. You could argue that there are very few differentiating factors between a partnership and a company, or a limited liability partnership and a company. Because in a limited liability partnership, you would have limited liability. There are registration requirements. You would have a separate legal entity in the form of the partnership. You can transfer out your equity in the partnership. So, in other words, it's going to be very difficult to distinguish between a limited liability partnership and a private company. The only distinguishing factor that I've seen is that there is a legal separation between the ownership and the management of a private company, something that you will not see in a limited liability partnership. Now, let's see how this works. Shareholders have put in money into a company. They're too busy or they are too insignificant in the larger scheme of things to actually run the company. So the theory behind the separation of ownership and management is that these shareholders will appoint professional business people or professional directors to actually run the company. These directors will act as agents of the company, they'll act as trustees of the shareholder, and they will administer the company, which is basically the three primary duties of a director. However, this also creates certain agency problems. Now, what is an agency problem? Let's take an example. Let's say you're ordering a pizza from Domino's, and the pizza delivery guy hasn't eaten in 2 days because for multiple reasons. So he's picked up the pizza from Domino's. It smells amazing, and on the way to your house to deliver it, he decides to have a slice of pizza. Now, let's see who the agent is here and who the principal is. To begin with, Domino's is making a sale to you, and Domino's is handing over some goods to its delivery agent, this delivery boy. Thus, a principal-agent relationship has been created between Domino's and this delivery person. Now that goods have been bailed from the principal to the agent must make sure that he takes care of the goods as if they were his own, that it must be protected and it must be delivered to you, the customer, in the manner and with the purpose it was supposed to be delivered. However, the agent did not do that. The agent flouted his responsibility and ate a slice of pizza. Now, this is an agency problem, right? And there are, of course, many ways of defining agency problems. We just used one in terms of a hypothetical. And there are many ways of tackling agency problems. Let's take something a little more serious. So, for example, let's say you are a DTC bus driver, Delhi Transport Corporation bus driver. You are required to take possession and control of an asset which is far more valuable than a pizza. And you're supposed to drive it around Delhi in a particular route. Now, you may decide not to follow that route because, well, you felt like it. But should you be able to do that? Absolutely not. As an agent of the Delhi Transport Corporation, you are required to ply a particular route. Now, what can Delhi Transport Corporation do to ensure that its buses are plying regularly on the routes that they are required to ply on? Well, the answer is fairly simple. We can use technology. We install a GPS tracking device in the bus and we monitor it real time to ensure that bus drivers aren't going off their route, they are not stopping infrequently, and they're not speeding either. So this is just one way of using technology to tackle agency problems. However, we can use regulation or laws to also tackle agency problems. The entirety of the principal-agent relationship as defined in the Indian Contracts Act tackles exactly this, the principal-agent problem. Now, why are we talking about agency problems and principals and agents when we are talking about company law? Well, when the shareholders of a company are appointing directors, what they're effectively doing is saying that, look, we have invested X amount of money into this company and we are turning over the day-to-day administration and management of this company to you, the director. In other words, I am creating a principal-agent relationship between the shareholder and the director, where the shareholder is the principal and the director is the agent. What this means is that the director has considerable control over the assets of the shareholder, over the amount of money that has been invested by the shareholder. Therefore, we must develop laws and rules and perhaps even norms to ensure that the director does not use these assets, this investment, for private purpose, for his own personal gain. He must use these assets, these investments, judiciously for the best interests of the company and to provide a profit to shareholders. In other words, we must ensure that the director acts according to the overall plan put up by the shareholders. Now, where would we find this law? Well, the answer is very simple. The entire gamut of what we call corporate governance seeks to reduce the agency problems created between the shareholders as principals and directors as agents. In other words, the separation of ownership and management is kind of managed and kept in place by our ideas of corporate governance. We find them in the Companies Act, in the listing regulations, and so on and so forth. So, the 5 principles of company law. Legal personality, a company has its own separate legal identity. Limited liability, and these two are a pair. Shared and transferable ownership, and a separation of ownership and management. These are the 5 key principles on which the rest of company law is based. Next up, we'll be discussing some terms that we will be using quite often throughout this entire semester, and I want to ensure that everybody's on the same page when it comes to basic terms and terminology that we use in company law.